Yes, Keanu, I think we can begin. Thanks.
Okay, thank you. Ladies and gentlemen, dear webinar audience, good morning, good afternoon, good evening, depends on where you are. Welcome to our webinar, Establishing Yourself in International Arbitration. I'm Keanu O, co-moderator of this webinar alongside with famous arbitrator Martin Holland from Brook Chambers. Today, we have got a stellar lineup of speakers. Karen Goff, Stephen Lim from 39I6 Chambers, Danny Jing from Jim Partners, all internationally well-known arbitrators. We are delighted to convene this virtual gathering where we will dive into fascinating world of international arbitration. International arbitration has gradually become the preferred methods of dispute resolution for parties involved in cross-border transactions due to its neutralities, flexibility, and enforceability across jurisdictions. However, establishing ourselves in field of international arbitration requires a unique set of skills, forward-thinking strategies, and profound understanding of legal and commercial intricacies. Today's webinar provides rare opportunities for professionals from diverse backgrounds to gain valuable insights from our esteemed speaker, Danny, Karen, and Stephen. As the only non-arbitrators on the panels, I'm particularly excited to explore the world of arbitrations alongside with our esteemed group of professionals. While I'm not arbitrator myself, I have a strong interest in the field and looking forward to entering it in the future. Additionally, I would like to extend special thanks to Randa from IPBA for assistance in organizing this webinar. Randa shared some exciting news with us that our webinar has attracted a large number of registrations. With such widespread interest, I'm confident that today's webinar will boast enlightening and impactful. So before the webinar starts, I would like to conduct 2 poll questions. And I will ask Randa to raise the poll questions.
So I think on that first question, if we could invite everyone to give an answer, a yes or a no answer, and then to press submit. Thank you.
Okay. We already saw the first question, right, Steve? Yeah. Okay. We only have 70% people, audience are arbitrators. Most of our audience are non-arbitrators like me. Yeah. Okay, for the second poll question. Yeah, we have 44% choose yes. Yeah, currently act as a party representative, and 56% are not party representative. So I think just like me, the poll daters and most of our audience are non-arbitrators. So to kick off the webinars, I would like to post two questions to our speakers. First, how did you move into international arbitration and what were the challenges you faced? Second, what advice would you give on how to build a practice as an arbitrator? We will follow the order of Karen answer the first, Danning the second, and Stephen the third. So without further delay, let's hear from Karen. Karen, please.
Yes, well, good morning from London. And for once, the sun is shining. Challenges, how did I move into international arbitration? I was really very, very fortunate, actually, to get a break to move into the field of international arbitration. I took it as a subject at university because I thought it was interesting. And then I engineered myself into pupilages in places where arbitration was practiced at the time, because it was mainly construction and commercial work. Arbitration was a preferred course of dispute resolution in the work that I was doing. So I began to practice, but mostly in domestic cases, almost as soon as I was qualified. The challenges of getting into international arbitration as a representative, not so much, other than being young and a woman, which when I qualified were both severe handicaps. After that, I think really the latter, being a woman, and I think it's still a challenge for women to get into international arbitration, to act as arbitrators, although the balance is tipping a bit more in their favor, and there are some positive actions afoot in the world to help that take place. But the very first time I got involved in a big international case was really my great good fortune, and not anybody could expect to get that kind of luck. But I was appointed as one of the first tribunal secretaries in a massive ICC case, and the panel was Professor Peter Sanders, who was one of the architects of the New York Convention and one of the founding members of ICA. Professor Berthold Goldman, also highly renowned French arbitrator at the time, and John Tackerbury, QC as he was then, KC now. So, and that arbitration went on for about 5 years. So the experience was amazing. And there really wasn't much I didn't experience during that time. And that really set me up to get into the field of international arbitration. After that, I joined the Chartered Institute of Arbitrators and began to qualify myself. So I'll leave that there for the moment and let someone else speak.
Okay, well, very impressive sharing from Karen. So let's move to Danning. Would you share your idea on these two questions?
Thank you, moderator. Actually, I started my international arbitration practice in 1990s. But that international arbitration, it was only limited to the international arbitration in Beijing. Actually, it's not real international procedure, but we handle international disputes between many foreign parties with Chinese parties on international trade, meaning the trading of physical commodities and goods and equipment. In 1990s, in the mid 1990s, there's a wave of Chinese economy from a high speed increase to a little bit decrease on the economy. So many breaches under the international trading contracts. I was a graduate student from in the University of International Business and Economics in Beijing, and the CTEC at that time was the only international arbitration institution in China, I think, before the enactment of Chinese arbitration law in 1995 or 1996. I studied as a trainee with a Chinese law firm, King & Wood. I participated in almost 20 or 30 cases, in the first 2 years of my traineeship. Then I handled many such international trade arbitrations in my career following that period. Until 2008 or 2009, there was a real need of international arbitration in other jurisdictions. My first big international arbitration case, I think, it happened in Hong Kong, HKIC. At that time, the instruction is to me was given by a Chinese company in a shareholding agreement dispute with an American party. Only until then, I think, this was my first time, to get involved in real international arbitration. So one big challenge to me is I discovered that international arbitration procedural practice was quite different to the Chinese international arbitration. But they share a lot of same, concepts. So I need to learn quickly how to play in the international arbitration in Hong Kong, and then later in London in the ICC case, and in some other jurisdictions. At that time, I have some colleague, from Western country. One of my team member was from Australia, and he was very good, and he taught me a lot, on the real international arbitration procedure. And until now, I think there is still difference between Chinese international arbitration and Western international arbitration, and the Chinese institutional rules and the Chinese arbitration law is moving to be more internationalized. So I hope, the gap of the two system can be harmonized more. That is what I how I was moved to international arbitration.
Okay, thank you, Danny. Your experience sharing for us has given us a lot of inspirations. Thank you. Okay, let's move to Stephen. What's your opinion for these two questions?
Thank you very much, Keanu. I'm very pleased to be here as part of this webinar with all my fellow panelists. And thank you to everyone who's joined us today. My answer, the short answer I can give, and the truthful answer is, it was being in the right place and at the right time. I started practice about late 1993 in Singapore. The SIC was established in Singapore in 1991. There wasn't very much international arbitration going on in Singapore at that time. There was domestic construction arbitration, but it was conducted in a way which was very different from how international arbitration is conducted. It was conducted as a proxy to how proceedings in court are being conducted. I remember when I took on my first case in construction arbitration, working at that time with Sundaresh Menon, who is now Chief Justice of Singapore and a very, very well-known international arbitration practitioner himself. He told me, well, it's not that different from court practice. That was the state of understanding of international arbitration at that time. Instead of calling it a statement of claim, we call it points of claim, but in everything else, it proceeds like it would in court, and we had further and better particulars and other things which may sound very alien now to international arbitration. I didn't seek out particularly to practice in international arbitration, which is why I said it was in the right place and in the right time, because there wasn't much arbitration. I wasn't very aware of arbitration when I was studying law. I don't believe it was offered as a subject when I was studying for my bachelor's degree at the LSE at that time. It was offered when I went to Columbia Law School for an LLM, there was one course, but I thought arbitration at that time was more about procedure. And one of the subjects I didn't enjoy very much when studying law was civil procedure and criminal procedure. So I decided not to go for that, to my ignorance at that time, and took more substantive topics. I got into arbitration through construction, as I mentioned. And the reason why I got into construction work was because at that time, as I said, I was working with a practice led by Sunderesh Menon, and he was doing work regionally, and it was more the regional aspect of it that intrigued me, doing work outside of Singapore, which is quite novel at that time for a Singapore law firm, rather than the practice itself. But it was surrendipitous, I would say. I started getting involved in arbitrations, and then moving on from that into international arbitration. My first international case was around 1999. It was the first ICC case that we handled. I remember being sent to Paris to do the PIDA course to understand the world of international arbitration. And then the practice developed from there. As the practice of arbitration in Singapore developed, as more international work came into Singapore, I got more opportunity to do more international work and to diversify the work that I did from construction work to general international commercial work, which is what I do now primarily. So it was very much being in the right place at the right time. Even though I say it was serendipity that took me here, I think I certainly caught the bug. And I now practice exclusively in international arbitration. I've done so for about 25 years. And there's so many fascinating aspects about arbitration that I could go on and on about it if someone didn't stop me. So I don't want to give the impression that I have no passion for the subject. I have great passion for the subject, but I fell into it by accident, as most of us do. In terms of challenges, again, I think I had the benefit of being at the right place at the right time. I was practicing in Singapore at the beginning of the development of international arbitration in Singapore. So even though the subject was new to me, even though the practice was new to me, since there weren't that many that were experts anyway, there were not, in that sense, great challenges in that I had to come up against others who are much more experienced in the field, had many more opportunities to handle more cases than I had at that time. We were all developing together. If anything, the challenge might have been breaking into the international arbitration circle, which, at least from the perspective of somebody who was practicing in Asia at that time, was dominated more by the international law firms, the Western law firms, the English law firms, the American law firms, the French law firms, etc. And firms in Asia were not doing this very much at the international stage. And there was obviously some effort for us to break into it, but it was a gradual process. I wouldn't say it was something that was a huge hurdle put in our way. As the work developed in Asia, then we developed with it. I don't think that there were huge hurdles to put in my way in getting that experience that I needed to develop my understanding and practice of international arbitration. Let me hand this back to Keanu.
Okay, thank you, Stephen. You mentioned it should be the right place and right time. Do you think it's the right time to be an arbitrator? Because most of the audience from of this webinar are non-arbitrators. Do you think it's the right time if I want to be getting into the area of the arbitration?
I presume you're putting that question to me. Each time and age presents its own opportunities. I had the opportunity at that time of being in a growing nascent field. So as I said, there were no great big barriers to entry, and I had the opportunity to develop along with the development of the field. The opportunities now are different. There are opportunities, but they're different in that if somebody, a young lawyer, caught the international arbitration bug early, they can start from a very, very early age. They can take numerous courses offered in many law schools across the world in international arbitration. I've seen the courses that are offered at the National University in Singapore. There is not one course, it is multiple courses delving into many, many different areas in international arbitration. So you can start at an early age and gaining the the theoretical aspects of the practice before you even get into practice. Once you get into practice, then you are sport for choice as to how you want to get in. It is very competitive. So that's the disadvantage, but you have choice. There are many practices now, looking just at Singapore where I practice. There are many law firms now that practice in the field. So there are many opportunities for you to get into practice that way. But that's not the only route now. There are other routes to enter practice. You can work for an institution. Sometimes institutions generally would want you to have practice a year or two, but shortly after that, you can work for the institution in the SIAC and gain an insight into arbitration working within the SIAC. There's much more scope now to get work as a tribunal secretary. Karen said that she had the opportunity to do one of the early ones. Now, there are many opportunities to get tribunal secretary work if you want to. So there are opportunities. It's just different opportunities. The competition is stiffer, I would have to say. So that probably I would see would be the challenge, and that many people want to do it. So you have to make yourself stand up to get those opportunities. But the opportunities are certainly there.
Okay, thank you for Stephen's wonderful sharing. And next, I will pass the moderation duty to Martin. Martin is also a seasoned arbitrator. Actually, we had a discussion before about this webinar about the arbitrations, because I told Martin I'm not the arbitrators. I specialize in corporate finance. So Martin already gave me a lot of tips about how to get into the arbitration field. So please, Martin.
Thanks very much. Perhaps it would be helpful to pick up the points that Stephen's just raised as to how one might get into arbitration. We saw from the poll, I think, that 83% of our audience don't currently sit as arbitrators, but I'm sure most, if not all of them, would like to. So we'll have a look at that. But can I just say that there is a Q&A facility at the bottom of the screen. So if any of the audience want to ask some questions of the panelists, do feel free to type in your question there. Keanu and I will try to pick up those questions as we go through our session. But let's pick up what Stephen was saying. Can I ask perhaps Karen, first of all, what advice would you give to the would-be arbitrator? We know it's difficult to get into arbitration. Stephen's given us a few ideas. I think with an eye both on the young practitioner, but perhaps also the seasoned lawyer who's built up a practice, built up areas of specialization, but hasn't yet moved into arbitration and wants to. What advice would you give to each of those categories? So Karen, over to you. Thank you.
Well, if we start with people wanting to do counsel work, I don't really think I can add a great deal to what Stephen said in that respect. There are some brilliant courses now. I mean, he mentioned the University of Singapore, College of Law in Australia and in wider Southeast Asia. There's King's College in London. Most universities in the UK and further afield now, even at undergraduate level, offer options to do dispute resolution. And I think if you're wanting to break into arbitration, you shouldn't ignore the broader category of dispute resolution work, because I think that somehow helps you. When I was thinking about this, I thought an opportunity which presents itself now, which didn't present itself to me when I was first in practice because it didn't exist, except in a few construction cases, was to do adjudication work. And I think if you want to get practice as writing awards and things like that, or acting as counsel, get involved in adjudications. There are a number of places in the world that have statutory adjudication systems. They're very fast track, but you see now also in arbitration that there are expedited arbitration practices. So you gather experience wherever you can find it, and don't just look in the arbitration area. I think in terms of training, it's also useful to join an arbitration institution that trains and do some of their courses, get on some of their panels, particularly scheme panels. They may only be domestic arbitrations to start with, but learn to write awards and decisions. That's extremely helpful. Stephen mentioned, and I've noticed looking at some of the people who now practice as arbitrators, I remember them when they were case counsel at ICC, or at LCIA or the Permanent Court of Arbitration in The Hague. You shouldn't underestimate the places and kinds of work that will give you really relevant experience. And they will also put you in contact with, connect you with, if you like, the arbitration community. Council work, as Stephen said, that it's easy enough to get if that's what you want and you got the right credentials. Arbitration work, it's still very much, you need a break somewhere along the line. If you can't get anything else, do some shadowing. Try and find yourself a mentor, sit with somebody that is actually doing an international arbitration case and get some credentials in that way.
That's very helpful. Can I ask this? I'm conscious, of course, that you're a past president of the Chartered Institute of Arbitrators. Would you say it's really vital to go down the Chartered Institute pathway route, become a member, become a fellow? One sees some arbitrators haven't taken that opportunity, but have still built a successful practice. Well, what would your advice be around Chartered Institute membership and fellowship?
Well, I mean, I'm sort of a career-long member of the Chartered Institute of Arbitrators, so I would be slightly mad for me to sit here and not recommend it. It's what I did. I joined the Chartered Institute and I joined its council. And again, there were almost no women at that time on a 30-odd strong council. But then I sat as members of members and chairs of its Education Training Committee and then its Arbitration Committee. And then I chaired its executive board before I became the president. And I was the youngest ever president. I did the fellowship before I was supposed to. I had a bit of a wrangle with them to give it to me because they didn't realize that I wasn't 35, which probably wasn't as flattering as some other things that have happened to me in my life. But those things are important, actually. I think showing to people who don't know you that you have credentials and also that you are known, you need people to talk about you. So also public speaking is helpful, but being seen to be educated in the subject is a very good thing. It's very difficult to get ahead of the field. Stephen talked about competition, and I don't think people should underestimate the competition that's out there. And so anything that puts you ahead of the pack is useful.
No, thank you. Can I just ask this before I pass over to Denning? Both you and Stephen have mentioned the value of sitting as a tribunal secretary. Just to assist our audience, how does one go about trying to get that appointment? Is it a question of approaching the arbitral institutions? Is it a question of sticking an advert in somewhere? How does one actually go about seeking those sort of appointments? I think that's a question that one often hears posed, particularly from young lawyers.
Well, other than dumb luck, I think there are now courses actually for tribunal secretaries. And so you can do courses. That helps a lot. But actually, what I see with a lot of people, I'm doing a huge case at the moment. We have a tribunal secretary. She was actually, before we took her on as our secretary, she was working as a personal assistant to the chairman. She was a secretary to the chairman. She was a qualified lawyer. The idea that tribunal secretaries are only administrators is wrong. They are generally quite well qualified young lawyers. So they may be associates in practices. It's very common, I think, now at the English bar for young practitioners to offer themselves as tribunal secretaries. Obviously, it's not that well paid work, but you get an unparalleled experience and then your name gets pushed around. And I've noticed the tribunal secretary that we recently took on in this big case, she now generally just does tribunal secretary work. And I think she'll do that for another 2 or 3 years. And then she'll be a very competent young arbitrator. So I think, again, you need a bit of luck, but you actually position yourself. Becoming somebody's assistant when you know they're an arbitrator, that of course helps. And then you can morph from one into the other. I'm not sure whether the institutions have panels of tribunal secretaries that they themselves will appoint. But if they don't, I can see that coming down the track.
Karen, thank you. Can I turn to you? You've got particularly strong and I guess unique experience in combining practice in Asia and outside of Asia. I'm obviously conscious that we've got an audience that straddles most regions of the world. What advice would you give in the light of your experience to someone who wanted to build a career as an arbitrator, or indeed as a party representative, but particularly as an arbitrator? What advice would you give to the young lawyer, equally the seasoned practitioner who wants to move into arbitration? Denny, over to you. Thank you.
Thank you. My colleagues have already mentioned a lot of many routes, which you can approach the career as an arbitrator, including education in law schools, acting as tribunal secretaries. In China, I think the secretaries are all employees of institutions. But in other jurisdictions, I think the secretaries, many of them came from the colleagues of some of the presiding arbitrator. For example, a legal assistant in the law firm of the presiding arbitrator, maybe he or she can act as a tribunal secretary. And also, to my knowledge, I know that in Hong Kong, some young barristers, they are also, elected as tribunal secretaries by other senior counsels as presiding arbitrator or the tribunal. In addition to that, I think based on an assumption that you have already party representatives, otherwise you have to go through this career path first. I mean, to lay down the foundation of dispute resolution, right? Because there's no possibility that arbitrators come directly from students, law school students. You have to they have to come from as a former judges or professors of law or some experts in certain industries, and most of them, I think, come from party representatives, come from law as lawyers. Based on that, I think you will have many choices today. For example, first of all, you can attend all kinds of international conferences in the world. They're coming the ICA conference in Hong Kong in early May, right? I think many practitioners in this region will, or from all over the world, will fly to Hong Kong to have person-to-person meeting. There are many of these conferences in all the major jurisdictions in the world. For example, I think these days the Paris Arbitration Week is ongoing, right? And the Arbitration Week of California is just finished, and also many arbitration conference weeks or arbitration day in China as well. The Beijing Arbitration Week or the Shanghai Arbitration Week. First of all, you need to come to meet people, because you need people to appoint you. You need the party representatives to appoint you, all the institutions to appoint you. This is the first tip. The second one, I think you can build up your own expertise in certain legal fields. You can write articles to publish your articles in, for example, Crowell publication. For example, some people just discussing with me on some article, but I still need time to write. I think I still need to explore this area to write articles on certain subject to let people know what is my experience and what is my view on certain legal issues. Of course, this will be a little bit risky if some people raise some issue conflicts. But compared to doing nothing, I think you have to do something to build up your own fame of expertise. And there are also so many moods today. Moods. In Shanghai, Shanghai just finished a Shanghai Mood competition of between university students on mood, on the like oral hearing or written submissions competition. I think if you have experience as party representative, then you can you can act as the moot arbitrator. I think this is also another very good route to know people in this field, and also to get into some not real case, but very good experience on how arbitrator functions. Thank you.
Thanks very much for that. And I think you've highlighted, of course, the value of contribution to blogs, and you mentioned the
blogs,
arbitration blog, which is very helpful. Obviously, as you've said, conferences, the importance of networking, particularly within the context of arbitration where one has private hearings. I think clearly very important there, and that building up of experience. On that topic, Stephen, you kicked us off with some initial advice for the would-be arbitrator. Anything else you'd want to add to what Karen and Denning have indicated?
Shall I focus specifically, Martin, on getting work as arbitrator rather than party representative at this point?
I think that'd be particularly helpful. As you explained earlier, your practice is exclusively international arbitration. So I think an insight from you would be valuable. Thank you.
Of the challenges that we're discussing, I think the most challenging aspect of getting practice into international arbitration is getting work as an arbitrator. I have to say that is probably the most challenging. It's not impossible, and I have developed into my practice now as primarily as arbitrator. I don't do much counsel work at all. I primarily sit as arbitrator, so it is possible. But it is challenging, and I would probably say it's even more challenging now than it was when I started doing it, because when I started doing it, I was at an earlier stage of the development of arbitration. But there are things that one can do. So how did I start getting work as an arbitrator? I got my first appointment as an arbitrator from the institution. I think for most people, that is likely to be the way you're going to get your first appointment. As you know, arbitrators are either appointed by an appointing authority, and most likely it's going to be an institution these days, or you are appointed by a party, which usually means you're appointed by a law firm representing that party. It's quite unlikely that a law firm is just going to appoint somebody who has had no prior experience sitting as an arbitrator, as a party-appointed arbitrator in a case, particularly if that is a relatively high-value case. The institutions, on the other hand, get a wide range of different disputes, and sometimes they get small-value cases, which provides for a single arbitrator, a sole arbitrator. And one are unlikely to get an experienced arbitrator to take on that case because of the amount in dispute. But two, also, and many institutions are now pushing this, they want to develop the field of arbitrators. So they would then be looking to appoint new people. They would specifically be looking at appointing new people who haven't sat before, who they think can do the job, and that's likely to be your first appointment. And that was my very, very first appointment. And how did I get that appointment? By obviously making myself visible to the institution. I got to know the people who would be involved in the institution. My first appointment actually was an ICC case. And I got to know the counsel that ran the Hong Kong office of the ICC at that time. And she recommended me and said, well, we need a sole arbitrator. And it involves Singapore, where I was from, and said, why don't we think about Singapore? So that's one way of doing it. Other ways of getting your appointment, Martin, you asked Karen about getting the certifications. I agree with Karen. It's very, very helpful to get the certification. I've taught on the CIARP fellowship course. I've taught on the SIARP, Singapore Institute of Arbitrators fellowship course. It's a good way to get some sort of certification to say that you have some knowledge and expertise of that area, particularly if you haven't practiced as counsel in that field. The one thing I would say here, though, is that while I would recommend it to everyone, and that's the route I took myself, I rather later than Karen, but I did go through the Singapore Institute of Arbitrators course and the Chartered Institute course and became a fellow of both institutions. And more importantly, I think became active in both institutions, being active in the Singapore Institute, being on the council of the Singapore Institute, and with the Chartered Institute in Singapore through the Singapore branch. But one thing I have to caution, and I say this to people who I do peer interviews of, to become fellows of the Chartered Institute, that getting a fellowship either of the SIARP or the CIARP isn't going to guarantee you your first case as arbitrator. It's a small step in that direction, but it's not going to get you your first appointment. So there's a lot more that you have to do after you take that step. As I said, it's more likely than not that you'll get your first appointment from the institution. So you should make sure that you're very well known to the institution, particularly those that are looking at appointing new arbitrators. I know the SIAC does it, and many institutions do it. So make yourself very visible to them. And that's more likely the way you're going to get your appointment, in my experience, than any other route.
Stephen, thanks very much for that. And I think you obviously emphasized the importance of getting yourself known within institutions, getting on panels. Probably worth mentioning that of course, as technology moves on, there's likely to be more online arbitration institutions and facilities. I'm conscious that in Hong Kong, there's EBRAM that does online arbitration. So there's opportunity for young practitioners to join those panels. I think that's tremendously helpful, Stephen. Thank you. Can I ask this? I'm conscious that among our audience, we've got practitioners from both common law and civil law traditions. Inevitably, we'll have some of our audience who are in jurisdictions with a split profession, solicitors and barristers. Even those in a fused profession, we know that classes of trial attorneys or advocates always sort of appear and always become a niche interest. I just wonder, from the point of view of getting appointment as an arbitrator, is it more difficult, for instance, if you're a barrister or an advocate rather than a solicitor or a lawyer in let's say, a large international firm? Is there a difference in approach that a would-be arbitrator should take? Are there different opportunities, perhaps even different challenges that might arise? I'm sure that's something that many of our audience are thinking about as we speak today. Karen, can I ask you your views on that? Thank you.
Yes, well, I'm a practitioner that spent my entire professional life as counsel. So I really speak from that perspective. But when we were thinking about doing this session and talking about it, that was my thought. Is it more difficult if you're counsel? I'm also an attorney, so that's a fused profession, a license to practice in the Caribbean. But even so there, I only take counsel work because of the professional regulation as a barrister in the UK. So wholly counsel practice. And I think it is more difficult. And the first reason really it's more difficult is you have far less client contact. You're a referral profession. So your work comes through solicitors. It comes through in-house counsel. you don't really get very close to clients. You don't get that opportunity that solicitors have to really make relationships with clients. And I think, I don't know, Martin, you're obviously counsel as well, but I think certainly in early years of practice, and probably even now, your training is to stand back from clients, because what you're trying to bring all the time is a level of objectivity. You're trying to add value over and above what the solicitors do for clients when they represent them. So you don't get that instant client contact. And I think that is a bit of a drawback when you want to work as an arbitrator to begin with. But then down the line, the fact that you don't have relationships with any of these people perhaps is more of an advantage. You know, you may have represented a party 20 years ago. That wouldn't really trouble anybody as a conflict now. If you're in a firm and your firm has represented them, it probably continues to do so in different places, and therefore you have a much bigger risk of conflict. And so I think that is probably a drawback for solicitors. But I think to begin with, certainly they have that advantage. And I think that as counsel, you are thrown more into the business of good networking. And sometimes the character of counsel isn't all that good at networking. It's a really forced thing that you have to teach yourself, is to go out there and clap hands people and get to know people. Public speaking, again, you think as counsel that naturally we would be good public speakers, but actually what we're good at is looking at a court and speaking to 2 or 3 people. That we can do really well. When you stand up in front of hundreds of people, it can be a bit daunting, but you've got to do it. Writing, we're good at writing, and so writing is a good way for us to express our views and opinions about things and show people that we can articulate on paper, if not in any other way. And I think Denning mentioned moot participation. I think young counsel participating in moots, either advising teams or sitting as young arbitrators, I think that's a really good way to get in and to sort of break through the barrier, I think, that personally I do perceive that being a barrister has. I'll let somebody else talk about the solicitor experience, because I say I've never had it, never been near it.
Karen, thanks very much. And I think, yes, I think one of the difficulties for counsel is that counsel is always not terribly good at marketing, not very good at actually marketing ourselves. I think that's a skill that those members of council listening should perhaps have in mind. The need to build up some marketing skills. And you've mentioned the importance, and Denning indeed raised the issue of sitting as a moot arbitrator, a moot judge. Incredibly important, not only from the experience point of view, but of course, again, building networks, sitting on moot panels of 3 with practitioners from other jurisdictions, building those links. Denning, let me turn to you on this issue of respective difficulties for perhaps the lawyer in the large firm, perhaps an international firm on the one hand, and the lawyer who's made a career out of being an advocate, out of being a trial attorney. Denning, of course, you're from a civil law jurisdiction, so have a particular perspective that I think would be very valuable for our audience. So, Denning, over to you. Thank you.
I think, you know, to have more opportunity, right? To have more opportunity to sit as arbitrator. Working in big law firms will have some barrier. Last year, you know, I got 5 inquiries from an international arbitration center outside of mainland China. But in all these 5 cases, you know, my former law firm, they all represented for or against one of the parties or one of the affiliates of one party. In that case, I have to disclose the potential conflicts, then I got no appointment at all because nowadays there are so many arbitrators competing, and if you have any clues of conflicts of interests, then your disclosure, you have to disclose it, right? Then it means the message is actually, unfortunately, I have no opportunity to act as arbitrator in this particular case. So this gave me a very big lesson last year. And at the end of the year, I decided to move from the big law firm to my solo practice. So now I'm, you can see my firm is a Jing Partners, means a solo practice of mine. In that case, I think the conflict of interest issues will be solved. Of course, I'm still acting as a lawyer, but my work is only litigation and arbitration work, contentious matters. So I will fit into the needs, two kinds of different needs. One need is need me as a counsel, as a party representative. The other is as arbitrator. The big step I made is I eliminated maximum the conflicts of interest.
Denning, thank you very much. I think that issue around conflicts of interest, of course, is one that looms large. So I think it's helpful you've raised that. And of course, your path from large law firm to smaller boutique firm and your own practice is again, I think, an interesting one to hear, particularly as we know that around the world, boutique arbitration practices are growing and becoming a more familiar sight. So Denning, thanks so much for that. Stephen, can I turn to you? And I'm conscious, of course, that you're someone that's straddled both sides of the profession. You've been a partner in a large law firm. Now you're counsel. What would your views be on this issue of the potential sort of divide, as it were, in the profession as far as opportunities are concerned for particularly arbitral appointments? Stephen, over to you.
Thank you. Yeah, I've had the advantage of seeing this from both sides. I spent 25 years practicing in law firms before moving to the practicing at the bar about close to 5 years ago now. I think there are advantages to both routes. The advantage to practicing in a law firm is that I think it's easier to get into international arbitration if you're practicing in a law firm than from the bar. And I have to say that's a qualified answer because I don't, even though I practice now with 39SX, I don't practice at the English bar. But the sense that I get, and Karen can correct me, is that if you want to get international arbitration work as a junior counsel, it's probably, there's less of that going around than if you're trying to get international arbitration work in a law firm. You join the right practice, you're likely to get more exposure to international arbitration. So that's your foot in the door. At least you're in international arbitration, you're working in a law firm, and you're building up your expertise, you're building up your reputation, and at some point of time, your appointment will come. I'm trying to think back now. It probably took me about a bit more than 10 years to get my first appointment practicing in international arbitration, to get my first appointment as an arbitrator. Conflicts is a problem, obviously, when you are in a law firm. I was able to manage the conflict situation because when I started getting appointments, I was getting appointments mostly involving Asian parties. Most of my appointments still involve Asian parties. But I happened to be practicing in international law firms at that time that didn't have that big an Asian client base in those jurisdictions where I was getting the appointments from. So I managed to evade that conflict issue. I didn't get conflicted that much, but it is an issue. I know for some people who are in law firms that you get conflicts, and Denning mentioned that, and many other people I know who practice in law firms would face that problem. So I think that you probably get an easier entry in if you're on a law firm, but then the challenge comes when you're more established and you get more appointments. I think actually just listening to people who talk about making appointments of arbitrators, that it's what they're looking for most often, the default mentality when they're thinking we need to appoint an arbitrator, is they would look at those who are professional arbitrators. So I consider myself a professional arbitrator. Now, people who primarily spend their time practicing as arbitrators, or if they're not looking at a professional arbitrator, they're looking at the bar, particularly coming from Singapore, which is a common law jurisdiction. And when I mentioned the bar, more specifically the English bar, because there is no independent bar in Singapore. So they're looking at the English bar, specifically looking at English King's Counsel. Rightly or wrongly, but that's the perception. So I think if you've managed to get your foot in the door and develop your reputation in arbitration, primarily, I think doing the work as party representative to begin with you've got yourself been through that process, it's probably easier to get an appointment, I think, if you're at the bar than in a law firm, for several reasons. One is the law firm partner is going to encounter conflicts. The bigger the practice you're in, the more that practice is in international arbitration, the more likely you get into conflicts. Secondly, and of course, the bar is much less handicapped by conflicts. The other thing is that what are you looking for when you're appointing an arbitrator? You're looking at appointing that particular individual. That particular individual has struck you in one way or another as being one knowledgeable about arbitration, knowledgeable about the particular area of dispute, and it's going to be the barrister that's more often out there projecting themselves that way because they're acting as counsel in cases, or that's the way that the reputation develop. I think it can happen as a law firm partner as well, but I think it's more likely that you would be projecting yourself individually, your individual capabilities as a barrister than you would as a law firm partner. So it's two sides to this. One, there is a chicken and egg problem, I think, for the barrister to get into arbitration to begin with. But once they're in it, on the right track, the chances of getting an arbitrator appointment, I think, are pretty decent, particularly if you develop into a leading practitioner scene in the arbitration field. But it is easier, I think, for someone in a law firm practice to do that. So perhaps one route, which increasingly I'm seeing, because I have colleagues in 39SX who have taken this route, which is you start your practice in international arbitration at a law firm, and at somewhere along the line move across and become a barrister. Maybe if you really want to be strategic about it, that may be the way to go down.
Martin, back to your question about civil law and common law. I can add something. Actually, there's a barrier between civil law and common law, at least at the very beginning of your arbitrator's career. If you are civil lawyers, you have to let the institutions in the common law jurisdiction know that you have some qualifications on the common law, or you. I think the most important, the most straightforward thing is your qualification. For example, in Singapore, in Hong Kong, as a solicitor, or I think in Singapore it's very difficult. You have to be graduates from the Singapore National University, or you have some qualifications in other common law jurisdictions. But after institutions have some experience with you on certain cases, then I think this civil law or common law qualifications, no matter, play a role as a barrier, because they have trust on you. They know your capability of handling legal issues, no matter it's a common law approach or civil law approach. Actually, you have the real knowledge of handling legal issues from are working together with common law arbitrators. That's important. And other issues are nationality, because institutions in Hong Kong, Singapore, if they appointing some sole arbitrators or some presiding arbitrators, then that person should come from a from a country different with the nationalities of the parties. Then in combination, all of these elements, nationality, your own real experience, and your qualification in common law, actually this will make your first appointment as arbitrator, for example, a civil lawyer like me in Hong Kong and in Singapore, quite difficult. So you have to work more hard on all these different elements. Thank you.
Danny, thanks for that. And I think important to have those points raised. We know that very often civil law practitioners will say that although international arbitration is supposed to be a hybrid between those two traditions, it perhaps unduly favours the common law practitioners. I think it's helpful to raise that. On that topic, or perhaps on a related issue, if one is acting as a party representative, has built a practice as a party representative, but is also now looking to sit as an arbitrator, particularly with conflicts of interest in mind, would it be sensible, for instance, to look at a different geographical region to sit in as an arbitrator? Is it worth trying to almost delineate one's practice geographically, particularly with conflict of interest in mind? I'd be interested to hear what our panelists say about that, as I know that each of them has a practice that straddles more than one region. Karen, let me ask you, I'm conscious, as you've mentioned, that you've got your Caribbean presence and your Caribbean experience. I know you've also have experience in Asia and obviously in Europe. What's your view on that?
It's less of a problem if you're a barrister, I think, because generally the potential for conflict is smaller because you're a sole practitioner. Other barristers in your chambers may work for people. That doesn't put you in a position of conflict, although I'm conscious in the wider world, people do have a problem with even barristers coming from the same chambers, and they view the conflict situation differently. But when I was thinking about that, I thought, well, have I consciously gone down that road? And the answer is, have I done it consciously? No, but actually subconsciously. And actually, is that what I have done? And the answer is probably yes, because I work a lot with parties in Southeast Asia as a barrister, as arbitrator, but my work as counsel, the Caribbean, I think there are fewer opportunities for appointment as barrister, as an arbitrator in the Caribbean, because their arbitral systems have been, I mean, certainly they're coming up very quickly now, but they have been less developed. Their arbitration laws and their arbitration practice has been behind the game. As I say, in support of my colleagues in the Caribbean, they've really run up the curve in the last decade or so. And we see new arbitration acts in Jamaica and in Trinidad recently. And the level of qualification and education of Caribbean lawyers in dispute resolution and arbitration has also commensurately come up the curve. But there are fewer opportunities for appointment as arbitrator in the Caribbean, and most of my work in the Caribbean has been as counsel, although I have had one or two arbitration appointments as well. But they are very small island communities, and independence and certainly the avoidance of conflict in the Caribbean is much, much harder. So better to look elsewhere to get appointments as arbitrator, I think. And unconsciously, as arbitrator, I've done more work in the Middle East and more work in the Far East. So should you avoid it? There may be a good case for compartmentalization in that way. Have we avoided it? I think perhaps more senior of us no, but those coming through may like to pay greater attention to it, especially given the breadth of the competition.
Karen, thanks very much for that. Let me ask you that. With, amongst other things, conflict of interest in mind, is there tactical advantage for the would-be arbitrator to look at a different region to build his or her practice as an arbitrator, a different region from the areas they're actually practicing in as a party representative? What's your views on that?
Sorry, were you asking me that question?
I figured I was asking Kenny. Thanks, Karen.
I thought.
Okay. To me, I think there's no difference because all the cases I will involve or I will be appointed to be involved are all China related, and all these Chinese companies they have quite internationalized. So as I mentioned, the 5 conflicts last year in appointing stage were all came from other jurisdiction rather than mainland China. But I was still confident out. But one aspect in my practice is that I always representing foreign companies in mainland China courts and arbitral institutions, but I'm representing Chinese companies in arbitrations in other jurisdictions. I think that's the way that different clients will selecting me to play certain role in different jurisdictions.
Danny, thank you. I had some good tips on some lateral thinking there, I think, around building the practice. So thank you. Stephen, your views, if I may, on compartmentalization, building a practice as an arbitrator in a different region from the region where you practice as a party representative.
It's from my perspective, Martin, I think it's a good idea in theory. The difficulty that I see, speaking from my own experience, would be how you're going to put it into practice. How are you going to get your arbitrator appointments I think you're going to get your arbitrator appointments because you're known in that particular region for that kind of work. If you are known in that region for that kind of work as counsel, it's possible people will come to you at some stage and say, would you accept an arbitral appointment? If you're going to turn that down, but then think that I want to get an appointment in another region where I'm not known that well, I think it might be making it harder for myself to develop that arbitrator practice. There are people I know who, very well-known people in the international arbitration space who manage to balance both a practice as counsel and as arbitrator. Many names you could name, particularly from the bar, that do that, regularly sit as arbitrator and also as counsel, and also outside the bar. Many names, luminaries in the field, regularly sit as arbitrator, but also take on work as counsel. There are challenges, I have to say. I personally find it is it's challenging one in managing. I don't do much counsel work now, but I do some counsel work. If I get approached to do counsel work, I'll take it on. I find that doing counsel work makes it harder for me to manage my timetable as arbitrator. And I have been conflicted from taking on work as arbitrator because I had represented a party as counsel. And I had to disclose, and not strictly a conflict, but the party that was looking to appoint me as arbitrator was uncomfortable that I represented that as counsel. So there are challenges. As I said, some people seem to manage it. In theory, focusing on one location for one type of work and on another for a different type of work, in theory, I think, you know, it is a way of managing it. But I just wonder how you could actually put that into practice. It might be much more difficult put into practice than you would conceptualize.
Stephen, thanks for that. And I think the timetabling issue is an important one. We know how difficult it is sometimes to align diaries. So thanks so much for that. We've got a couple of minutes remaining, and I'm conscious that some questions have come in from the audience. So let me put these out to our panelists. Be good to get your view on this. First question is this. I think all three panelists have emphasized the importance of becoming visible if one wants to get appointments as an arbitrator, and the importance of using the institutions, whether for mentoring or shadowing or seeking tribunal secretary appointments. One of the questions is this: in practical terms, how would you advise the young practitioner to actually make themselves more visible to an arbitral institution? So let me throw that out to our three panelists and see who would like to take that one.
If I may, Martin,
Stephen, yes.
I do have some insight into this because I know how the SIAC operates. I know that they are always on the lookout. So how do they identify people who haven't sat before? One is they look at the lawyers who appear in the cases before them. So not as arbitrator, as counsel. They know who is appearing. If they've seen a particular person appear several times, then they get a little bit more comfort that that person has got experience. And I know that when the SIC looks at appointing an arbitrator for the first time, they will say, well, have we seen this person as counsel before us in many instances? So that's one way. The other way is, Denning has alluded to this, there's no shortage of arbitration conferences that you can go to these days. You could attend one every week if you wanted to, just going from one to the other. I don't recommend that, I have to say, but it's important to be part of the networking. And there are some of these conferences where the institution would be present. SIC run their own conferences, ICC do as well, HKIC, they all do. So if you want to get to know the council, then attend these events, make sure that you're known to those people in those jurisdictions as well, and get to know the council. And it's important to mention that it's well and good to get to know the CEO and the registrar, and you should, but don't underestimate the role that the young counsel plays in selecting arbitrators. The case first goes to a counsel. It is the counsel then who starts drawing up a short list for the appointing authority. It may be the registrar, it may be the president of the court, for example, will make that appointment. So you want to get yourself on that list to begin with, and it's going to be the counsel. So it's going to be easier because the counsel are relatively young. They've been in practice maybe a few years themselves. If you know them from practice previously, keep in touch with them, or just get to know them and just socialize with them in a social way as well, because that's just a way of keeping in view when they get more familiar, more comfortable with you. That's my take on it.
Stephen, thank you. Can I just see whether Denning or Karen would like to add anything to that?
No, not really, Martin. From my point of view, I mean, I think, you know, I've said this before, you have to be in the room, all the rooms that matter. You've just got to put yourself out there.
Thanks. Denning, anything you would add?
Networking and to know the councils are very important. Yeah, if you travel, you can just pay visits, to have a cup of coffee in the office. I think that would be a good idea to increase your visibility, you know, in the institution.
Thank you. There's another final question that's arisen. We've spoken about the value of the Chartered Institute pathway, membership and fellowship. One of the questions is there value in getting an advanced degree in dispute resolution or international arbitration? Is it worthwhile for the would-be practitioner to get a master's, for instance, in international arbitration? Would that give them a practical advantage? Again, let me put that out to our panel and see whether anyone would like to take that.
I think anything that puts you ahead of the crowd is a good thing. And it's a big crowd now. You shouldn't underestimate the size or the capability of the rest of the crowd. So if there's any particular aspect you have, even if you, for example, have a degree in something which is not law, you know, in engineering or some other skill that would be helpful as to an appointing institution to know that, and you could then get appointments in dispute that were relevant to that underlying skill. Anything that puts you ahead of the crowd. And in terms of arbitral experience, all of those qualifications are helpful. When we spoke about building confidence, when you look at case counsel, when you look at the institutions, they are obviously more confident, more comfortable with people who they know and who they know have got qualifications in the subject or the subject area of the disputes that they're dealing with.
Thank you. Stephen, anything again you'd add to that? Thank you.
I have seen a good number of CVs in my time and worked with a number of people as a case counsel in the cases that I sit on, and I take an interest in how they got into the role that they did. I think there are different routes to get into international arbitration. One is practicing in a practice that is prominent in the field, that does work in the field, and you get yourself known that way. If you're not in that situation, certainly I think getting a degree, and there's some degrees in particular which show a keen interest in the field. One that comes to mind is it's the MIDS course in Geneva that Gabriel Koffen-Koller runs, and it shows an effort, if you're not from within Europe, to go and get into that course, undertake that course, and it gives you that edge, as Karen mentioned, it gives you that edge. So it's certainly one way of doing it. I wouldn't say that you need to do everything. I mean, some people do, and obviously that makes them even more stand out even more. But I wouldn't say you need to do everything. You wouldn't need to get admitted into multiple jurisdictions. You don't need to practice in the top tier law firm and get a degree. You don't need all of that to succeed in the field. But each of these are possibly routes into with the foot through the door. And I emphasize again, it is the foot through the door. It's not going to set you down the road to a long and successful career in arbitration and sitting as an arbitrator, if that's what you want at the end of the day. It is only the foot through the door, and you've got a lot of other work that you need to do to propel yourself further after you've got your foot through the door.
Stephen, thank you. Denning, Councillor, you've got anything you'd want to add to that?
Yeah, this echoes, my comments before. I said, the barrier between civil law and common law, and if you can do some education, in other legal system, some legal education in the common law system, for example, for civil law lawyer, this will definitely help.
If I could just echo Denning, I know Denning has said that several times now, and I want to echo that, Denning. It is very, very important for anyone who wants to practice in international arbitration to develop a curiosity about the legal tradition that they haven't trained in. I think it doesn't matter whether you're trained in common law or civil law. You should show a curiosity and an appreciation of the different system that you come from. That's been my approach to practice. I'm a common law trained lawyer, but I've shown a lot of curiosity and appreciation of the civil law side of the practice. And I mean, I get appointed now in civil law cases. And that's because I've shown that I appreciate the difference, and I don't approach everything with common law lenses. So I want to emphasize what Denning said is important either way for you to have that curiosity and appreciation of the different tradition.
Yes, Stephen, thanks for echoing that, and obviously Denning, thanks for raising that. And of course, it emphasises as a truism the truly internationalised nature of this topic area. So, panelists, thank you all so much for that. I'm conscious that we put out a poll at the beginning on experience people had. I think before we conclude, it might be helpful to perhaps ask a couple more questions of our audience. So I wonder if I can ask Randa to put up a further question. In the light of what we've heard, do we think that our current skill set would actually equip us to sit as an arbitrator? So if I can invite everyone to give a yes or a no answer to that. Thank you. And let's see what the result is of that. So we've got 39% of our audience feel that they are equipped. 61% feel there's a bit more to do, and obviously there's some ideas that have gone out from our panelists today. Visibility, building networks, using the existing learning pathways, the Chartered Institute, for instance, and of course advanced degrees. I think that's very helpful. Let us also ask this: has this webinar encouraged you to pursue the building of a practice as an arbitrator? Do you feel enthused? Do you feel it's something achievable? Do answer that question. Thanks. And again, let's see the result of that. Well, that's encouraging anyway. 100%. So panelists, you've clearly enthused everyone to pursue arbiter appointments. So that's very encouraging. For the sake of completeness, I don't want party representation to feel neglected. So let's just finally ask this: Has what you've heard from our panelists encouraged you to pursue building or enhancing your practice as a party representative? So let me put that out to everyone. And again, let's see the result of that. So we've got a 95% a yes to that. So again, very, very, very encouraging. I'll pass back very shortly to Keanu for the final word. But let me thank Karen, Denny, and Stephen for their insight, for the very practical pointers and ideas that they've given to us all today, drawing on their experience. And unfortunately for us, it's been a very, very wide and varied experience. So thank you all for that, and obviously thanks to Randa and the IPBA for making this session possible. But to close, let me pass back to Keanu. Thank you.
Thank you, Martin. I would like to extend my gratitude to each and every one of you for joining us today. And it has been an enlightening and insightful journey, and I'm truly honored to be part of it. And our esteemed speaker, Karen, Denning, and Stephen have shared their years of knowledge and expertise, providing invaluable insight into the arbitration field. I'm deeply grateful for your contributions. Personally, I have learned a great deal from today's webinar, and I have picked up some key skills for international arbitrations and get some awesome tips on building a solid practice. The lessons imparted by our speaker has been truly invaluable. And as we conclude, for most of all our audience, whether you are considering a career as an arbitrator or a party representative, I hope that webinar today have inspired you to pursue your goals. Finally, thank you for all. Thank you for your contribution. Thank you. Thank you, everyone.
Thank you,
Thank
and
you. Thank
have a
Thank
great
you.
rest of the day.
Bye-bye.
Thank you. Bye-bye.
Bye.
Very much. Bye.
Thank you all.
Bye.
Thank you.